Good morning. Thanks for being here. It's very cozy, and for coming to listen to us at this early hour. I think it's fair to say that typically the law lags behind new technology and developments, especially digital developments, and that's ethical considerations associated with them. And it's often a question of corporate morality to see to what extent, even to what extent, companies are going to use data about individuals in their business interest. What level of detail they're going to be transparent about the use of data about people, about the way they store the data, for how long they store the data, and how good they protect the confidentiality, integrity, and availability of those data. Now, whilst there's clear economic benefits in trying to get value from data, there's of course increasing pressure on organizations to embed privacy concerns into their social responsibility, corporate social responsibility agendas, which in turn then may lead to competitive advantage over less privacy-driven, privacy-compliant organizations. Today we will be focusing on data protection as part of an organization's sustainability or ESG framework. And ESG is basically a framework that helps stakeholders understand how an organization is managing risks and opportunities related to environmental, social, and governance criteria. It's an acronym. It stands, as you might have well guessed, for environment, social, governance. And ESG takes a holistic view that sustainability extends beyond just environmental issues. My name is Tom de Cordier. I'm a data protection and cybersecurity partner in Brussels for a law firm called CMS. I had a team of technology and privacy lawyers. We act as external DPO, but also do we assist clients on various sorts of data protection projects, compliance projects, and a growing area also cybersecurity incidents. We assist clients in cybersecurity incidents. Now, I've got the honor of welcoming two esteemed speakers on our panel, and I'll start by Emmanuel on the far left of me, Vice President and Head of Data Protection, Export Control and Sustainability at Capgemini. For those amongst you who don't know Capgemini, it's a global leader in consulting, digital transformation, and technology and engineering services. Emmanuel, before joining Capgemini, she worked as a qualified lawyer for various international law firms, focusing on complex data protection matters, including international data transfers, cybersecurity, and compliance programs. Before that, she was a group DPO of a major, I think French headquartered IT company.
I work only for French companies.
And she started her career at the International European Department of the CNIL, where she managed mainly BCR reviews, and participated in the drafting and adoption of several opinions by the Article 29 Data Protection Working Party. This is now becoming more and more of a nebulous term, but for those of you who are old enough, they know that the Article 29 Data Protection Working Party was the predecessor of the European Data Protection Board. And in that capacity, she also took part of the discussions initiated by the CNIL with the European Commission on the preparation and adoption of the very well-known GDPR. Next to me on the left-hand side, Gintare, and if I pronounce your family name well, Pazerikaiti. Is that a good attempt? Okay. Legal officer at the Secretariat of the European Data Protection Board, focusing on data protection aspects specifically for new technologies. Before joining the EDPB, she acted as a group regulatory and privacy legal counsel for a major telecoms company in the Nordics. And prior to that, she used to be a public servant for the Lithuanian government, in which capacity she was involved in the GDPR negotiations, I guess for the Lithuanian government with the European Council. And Gintari holds a PhD in international public law. With this being said, and without further ado, can I please, first of all, invite Emmanuel to give briefly your perspective on today's topic, data protection and ESG.
Yeah, thank you, Tom, and Actually, before going any further, I'd like to maybe make sure that we all agree on the terminology that we use. You see in the media, in the news, letter that you receive in your email, a lot of articles which actually refer to ESG, sustainability, corporate social responsibility. And it's difficult sometimes to make a difference between those terminology to really know what is behind. I think we all get a sense as to the fact that, broadly speaking, sustainability and corporate social responsibility may be referring to something around environment. But today, we'd really like to make sure that you understand that it goes beyond the sole environment concern and that it's much more about the footprint that companies have on the society at large. So in order to maybe introduce this properly, I thought that having a quick look at the video on screen would help us and help you to have a good understanding, first of all, of what is meant by sustainability.
What is sustainability? One of the more common definitions of sustainability used worldwide is from the UN Brundtland Commission. They say sustainable development is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. So put simply, sustainability is about our kids and our grandkids. How do we live today so that they can thrive and future generations can also have a good life? Our planet has many resources that we depend on for food, for housing, and many of those resources can replenish. You can cut down a tree and grow new trees. You can catch fish and there will be more fish. But that only works if you do it at a rate that these systems can replenish. We call that the replacement rate. You could think of it as a bathtub, and you're draining the bathtub and filling the bathtub at the same rate. And if you do that, then the level of the water should be able to stay stable. We call that equilibrium. It's not that you're not using any resources, you are, but you're doing it at a rate that the systems are able to stay somewhat steady. Right now, and over the past few decades, what we're seeing is that we are consuming resources much faster than the replacement rate. And the result of that, draining the bathtub faster than filling it, is that those levels are going down. We're seeing fisheries disappearing and other ocean life. We're seeing forests disappearing. Of course, everyone is familiar with the impacts of climate change and, other impacts of this level of consumption, plastics in the ocean, all of these problems. So ultimately, sustainability is about understanding how all of this is connected, understanding that when you make a decision to buy a smartphone, you are impacting someone's life on the other side of the planet who's involved in mining the materials to put in that smartphone. So sustainability is about systems thinking. One of the other big frameworks that we use to talk about sustainability is the 3 E's. In business, we call that the triple bottom line. Some people call it the 3 legs of the stool. And that's environment, economy, and equity. And it's not just about understanding that we need to manage all of those. It's understanding how they're connected. So if you only look at short-term economic profit, then you're not going to end up with a thriving economy in the long term. If you're only looking at conserving the environment without thinking about economics and understanding, how people are making their livelihood, you also may not end up with a thriving society. And if you aren't looking at
Okay, so don't worry, I'll manage from there. So anyway, you'll tell me maybe, okay, that's very interesting that we are attending a privacy conference. So what is the relationship between the definition of sustainability and data protection? Well, actually, there is a strong link, and that's the entire purpose of our discussion today, is to demonstrate, as indicated in the video, and if we can come back to the slides, that would be helpful, please. If we can demonstrate the impact that data protection may have on sustainability at large, and to demonstrate how you can have an impact with data protection on sustainability, one key element is ESG, which is something, again, you may have heard about, which basically sometimes ESG is used as a kind of synonym to sustainability. But I'd like to clarify here again that it's not really synonyms. They are not really synonyms. Sustainability, as we just saw, is in relation to the impact in general that a company may have, and ESG will be here to support the demonstration of a company as to how it has an impact on the society at large, on the environment, on social, and on governance. Okay, so that's how you need to approach and think about the topic when linking data protection to ESG and sustainability. Is that saying, well, data protection is one pillar which may have an impact, and we will see on the different pillars that we have under ESG, simply because, first of all, it's a fundamental right. So obviously, companies which will care of a fundamental right and which will invest in a fundamental right will obviously support the sustainability principles as we have defined it earlier. Secondly, it's important to see, and that's something we'll come back on later, that more and more clients, when we as service providers are facing clients, but also in general investors, are looking at how companies are actually processing personal data, protecting personal data, and what is the ultimate impact on the value chain of the company. A company which has no investment, no governance, no policy on data protection will be considered as having some weaknesses in relation to his projection as a company which intends to be sustainable. So again, we'll come back on that. We are just setting up the scene here, but it's just to show you basically the link between those two. Obviously, to make to illustrate what I'm saying, at Capgemini, both ESG and data protection, both sustainability and data protection are very high in the agenda. But of course, as we will be discussing, we have been through a certain journey in order to make it obvious. And the idea is to share it with you today in order to understand how these are closely related, what, again, is behind the KPI that you find under ESG, because that's something you may not be aware of when talking about ESG, is that, as I said, ESG is about having some metrics, some key performance indicators, which will help a company demonstrate how it is actually implementing a sustainability approach. And those metrics, they are not coming out of my head. Actually, there are a certain number of international standards, which to date are not mandatory, but which are about to become mandatory because we are expecting some adoption at European level, in particular from the so-called EFRAG. But at least, there are some references to which we can you can have a look, and we'll come back on those to give you more details, which actually focus, for part of them, on some key performance indicators relating to data protection, which will help a company demonstrate how much it is investing on data protection, how much it is organized on that matter, and therefore how much it is protecting a fundamental right as the one that we are all familiar with. So now I think I hand over to Gintare on the ED.
Thank you. So I will just start by recalling that this is a very important week because, as you know, it's the 5th anniversary of the GDPR and also 5th birthday of the European Data Protection Board. So we are in a very celebratory mode this week in Brussels. And a birthday is always a good opportunity to reflect, where we stand. And I find this very interesting to be in this discussion today, because I think sometimes in a privacy world, we are very self-centered and we're living in our own bubble. And it's good to go out a bit of that and also try to see, the bigger picture and how privacy links to broader discussion about impact of society and social discussion regarding social issues. So that's a very interesting angle, and I think it also can give additional motivation for people working in this field and also for people driving compliance agenda in companies. Because sometimes we tend to get lost within technicalities and perceive GDPR as a certain very technical issue. And also when dealing with stakeholders, I know also from my own experience that sometimes it's very hard, to keep on selling the same ideas because it's seen as an additional kind of, okay, it's additional burden, additional restriction. Again, the privacy lawyers are saying you cannot do this, you cannot do that, and this can be perceived as kind of limiting innovation, new ideas within businesses. So it can also be very interesting to be able to explain the broader goals of why we are doing this here, and linking also to the social responsibility agenda. So I think this is also something good to know, because GDPR is getting a bit, in adolescence. So it's good to try to find new meanings to what we are doing here. And it links a bit to what Emmanuel said. I think that today, in Europe, when we speak about social responsibility, we cannot ignore the privacy element. It's just something that people expect. So it's you cannot be a good corporate citizen without taking into account the privacy and being serious about it. And we know this from various surveys that have been done, especially since GDPR started to apply, that it brought a lot of awareness to people about their rights, and they have a higher and higher expectations also towards businesses, and they are actually really looking for this privacy element. So it's something that is in a way inevitable, and for me it makes at least complete sense to kind of try to link it. And it also has a very practical implications, because people are also saying in these different surveys that they also are more comfortable in sharing their data with companies that show the privacy effort that we are taking. So it can also have a positive impact in terms of business development and so on. And maybe what is also easy is that GDPR already provides a very solid framework that gives, if you are serious about GDPR compliance, they have a solid privacy program, and you would be able, to know exactly what data you have, why you use it, what kind of to put in practice the controls, manage data incidents, and so on. So it's kind of already there. The challenge is maybe translating that into this ECG language, and making this link and being able to explain how these two are related. So I guess we will elaborate on that a bit later on. Thanks.
Thank you very much. And now trying to put the theory to practice, which very often, as we all know, is quite a challenge. Emmanuel, I understand Capgemini went through quite a bit of the journey in trying to weave in data protection into ESG, because for Capgemini, both data protection as well as ESG is high on the agenda. Can you give us a flavor of how that journey went in trying to get those two topics being interrelated?
So the first thing that we had to face is that basically the regulatory pressure on ESG sustainability is higher and higher. So it meant that the top management was super interested on how we could better position the company on all this with regard to all these regulations. And they were therefore looking for different areas within the company on how we could better support the compliance with its different pieces of legislation. So this is just to give you a flavor. I'm not going into the details because our topic is more on data protection. But just as you can see on the slide behind, obviously, all these pieces of legislations are actually behind triggering some obligations of reporting for most of them from companies. And reporting, when you talk about reporting from a pure business standpoint, that's something people know how to do it. But when it relates to things which are less tangible, and in particular in relation to your compliance with some pieces of legislation, with your gas emission and so on, as we will see, we have been able to demonstrate and to understand that data protection could be, with some core principle, a key element that would enable to demonstrate, for instance, that if you apply some privacy principles, you actually can have an impact on your gas emission. We'll come back on that later, but it's just to give you the first element of the journey was that top management realized that there was a high regulatory pressure, and have started to look everywhere in the company as to how we could react to this pressure and communicate better on what we are doing. The second element which has placed data protection at the core of the discussion in relation to sustainability is actually the fact that, again, the company being conscious about the need for being well positioned on the matter has been applying for some ratings in relation to sustainability. You may know or not that there are some rating agencies which are specialized on, ranking the companies depending on their score, on how they do address and how mature they are on ESG, corporate responsibility, and sustainability matters. And when Capgemini positioned itself, they did not, the top management and the team in charge of that exercise, we are a large company of 300,000 people, so, a lot of people, and they did not necessarily think about our data protection organization. They tried to manage the data protection part when answering to the first survey a bit on their own, or they contacted my team 2 days before the submission just for sanity check. The result was terrible because in the end, it happened that our first rating from rating agencies on sustainability, on the data protection part, was very low because we were not able, to really communicate and being transparent enough on how we were articulating our data protection program, how strong we were in our organization. So that's also how we came in the middle of the game as a data protection team, was that naturally, the team in charge of the reporting and to the rating agencies realized that there were core questions on data protection on which we really needed to strengthen our answer and to be able to demonstrate what we were doing. And it's a pity because we had everything in place already, a strong governance, a strong policy, a good network of people in the organization. And in fact, it was just more a matter of communication. And you may know that as lawyers, sometimes it's not our strength. We work, we deliver, we provide solutions, but that we are not necessarily good at advertising what we are actually doing. So the idea was for us, as well as a team, if we are talking about the journey, was that once it was identified as a key topic, make sure that we were able to translate into terms that would make sense for the market, what we are actually doing in terms of data protection internally. So again, it means being transparent on our data protection group policy, on our network, and so on. So we have decided to mobilize the relevant resources to better promote. But then we faced another challenge. So we made another submission the year after, which was much better. But we realized one point, is that the complexity of the key performance indicators that are defined in the standards were not necessarily mastered by our team. So we had to engage, as part of the journey, into some kind of training and getting more mature on how we digest actually the key performance indicators that are requested as a result of the standards. So that was also an important step to make sure that we would understand exactly what is requested. And one difficulty, I would say, is that most of the standards are defined for companies which are operating in B2C environments. And we are operating in B2B environments. So we had internally to translate those KPIs into a reality that is ours, which is not B2C, but more B2B, and make sure that we would be able to capture what the market is actually expecting us to capture. So that was also part of the exercise, to speak the language of the ESG and CSR specialists. And finally, and that's an important one on which maybe we will come back, but that I keep talking about KPIs. But for lawyers, again, KPIs, and for data protection specialists, that may be something a bit abstract or difficult to capture. So also we had not only to agree on what we would need to capture, but also how we would capture it. That's not natural, again, for most lawyers, to be, the one keeping track of some scoring on the number of data subject requests that you receive, on the number of data breaches that you have, having some track record of all these elements, is not necessarily something that we do. And I can tell you that in an organization of more than 275 employees, we located in 50 countries, if you don't have a strong organization and governance on how you collect those key performance indicators, you will fail. So that was also part of the journey, to define how we would be actually, collecting the KPIs and communicating on those to the market.
Thank you. I can imagine that's extremely complicated, especially for global multinational with 300,000 FTEs. It also means, I guess, because there are certain standards on reporting, non-mandatory for the time being, one of them being GRI. I think you already briefly mentioned at the beginning. The data protection, well, at least the data protection chapter, to put it in simplistic terms, of GRI, it's a relatively short document, right? And sets KPIs in a relatively high-level way. So I guess what you're also saying is that Capgemini, as part of this journey, had to kind of articulate these high-level KPIs in even more concrete and tangible and measurable objectives. Is that a good summary?
Yeah, that's correct. So as I said, the first thing was to really understand the KPIs that we needed to report on, and to make them again realistic with regard to our industry and to the fact that we are operating in a B2B environment. The second point was to make sure also that we would enhance our transparency. What does it mean? Is that one of the things that is expected from the rating agencies, but also ultimately from the investors, is that companies do not only do their own internal cooking and have a strong governance on data protection, but that they are also making it public and having some public commitment. So on that, two key pillars and two key elements. We've had to advertise a lot our so-called binding corporate rules. I don't know how much you're familiar with those, but at Capgemini we have binding corporate rules. So it's basically our group data protection policy, which have the stamp of the data protection authorities, to make it short, and which is basically our entire data protection governance within the group. But once you've said that, I mean, that's not enough. The investors and the rating agencies want you to tell them the story behind, to really understand that it's not only one nicely put together document, but that's something which is coming to life with a strong network, with some, process in place that would enable to actually demonstrate the implementation of the policy. So that was one of the key elements, was to be able and to be ready, because that's not natural to all companies, to be transparent on our internal processes in place in order to actually implement our group binding corporate rules. To give you then also illustration of another element that I was referring to, not only on the transparency but on the collection of the KPIs, it's important to make sure that you brief your network of data protection officers. As I said, we are in 50 countries. We have therefore 50 data protection officers, one in each country. And so we had to make sure that each of them would be collecting the KPIs. But if you ask them in January, don't forget to collect your KPI, and you come back to them in December saying, okay, so give me your KPIs, nothing will happen. Or the quality of the KPI will not be so good, because you have your day-to-day, you lose track of things. So what we have put in place is that we have asked the DPOs to report on a monthly basis, and we have an internal tool where we ask them every month to actually fulfill all the KPIs which we have defined, in order to be able to be ready to communicate to the investors and the rating agencies any KPIs that we would be asked to communicate. And to give you some illustrations, because you may think, well, which KPI could we speak about in terms of data protection? We have several. So to give you the most important ones, you have, of course, the number of data subject requests that we receive, the number of data breaches that we suffer, the number of data breaches that we suffer and which we notify to the authority, the number of audits that we have from clients, the number of audits that we perform on our own systems, the number of audits that we do on our third parties. So, there are a lot of those elements which are important, and on which we need indeed to collect every month to make sure that then the quality is actually good. And I'm emphasizing on that point because since the adoption of the CSRD directive, in January, as of 2024, many companies, and there are some waves, so it's 2024 some companies, 2025 some others, and 2026 the last ones, but all companies ultimately we'll have not only to report on this type of KPIs, which I just mentioned, but those KPIs will need to be auditable. So that's why I'm emphasizing on the fact that it's actually important to have a strong governance on how you collect the KPIs. It's because as of 2024 and ultimately 2026, all companies will need to be able to audit how they have collected the KPIs, demonstrate that, you know, it's not like things that you have decided with your wet finger, and make sure that you have a thorough process in place. So that's super important in 2023 to start thinking of this approach, to be ready when the legislation will be applying to all companies.
Super interesting, thank you. Jintari, you mentioned the important role of accountability obligations under the GDPR, important for ESG and sustainability efforts. Could you give some more flavor on this, a few illustrations and examples?
Yes, so for example, we just, Emmanuel just mentioned, you know, the number of data subject requests and that this is also something that is measured. And of course, you know, GDPR Chapter 3 already provides, you know, for requirements in relation to that. And then if a company takes this seriously and already have internal processes to being able to track and follow up on those, this is something kind of practical expression of that. And then, of course, we have further obligations in, for example, Chapter 4 that requires to have, you know, record of processing, so to know what data is there, how it is used, why it is used, for how long, how it is being shared. So keeping track, having internal processes for this. And there is also obligations to perform risk assessments, have, in some cases, do a DPIA and measure, you know, what risks are there, how to mitigate them. And that already comes from GDPR obligations. And then, of course, we have also rules regarding security or the need to, you know, to also engage with, to keep track engagement with third parties, how data are being shared externally with third parties, and also have safeguards in place regarding that. And then, of course, there is rules regarding international data transfers, and again, making sure that, you know, it's clear and it's possible to track how the data is being shared, where it is going, and put in place necessary, in certain cases, agreements, and make sure that there are safeguards in place there. So there is already a lot, and it is also worth remembering that, of course, it is always on the controller to being able to also demonstrate that compliance. So the burden of proof is kind of on the controller. And more broadly, maybe it's also worth mentioning Article 25 of the GDPR, which provides for privacy by design and privacy by default, which is kind of often used, you know, in broad terms and referred to a lot. But actually, Article 25 gives meaning to that and refers to specific measures that controllers should assess and take. And the EDPB has also issued guidelines on this. So if you haven't seen them, they are quite interesting because we also articulate on specific elements regarding the privacy by design. For example, making sure, you know, that from the beginning of any process, privacy is considered. And for example, you know, that only data necessary is being collected. So giving articulation to principle of data minimization. And privacy by default, then, you know, it's more relates to the settings and making sure that they are by default the most privacy-friendly option. So this is also something that is quite important in a broader picture.
Yeah, thank you very much. And yeah, on governance, I think just to make a very practical link, if you look at how the GDPR is structured and also the recommendations of the EDPB, if there's any data breaches, even the ones that you esteem are not reportable because they don't meet, let alone exceed the thresholds for reporting, there's an obligation to keep track of that, to record it, regardless of your ESG framework now. Then if you see what you said about reporting and KPIs, number of data breaches, even the ones that you didn't notify, I think the GDPR also almost already brings you halfway through to that kind of record-keeping discipline, if I can use that word, at least for lack of a better description. Emmanuel, you mentioned that the key data protection principles, especially the ones that are enshrined in Article 5 of the GDPR, like data minimization and security, can support efforts on the E for environment in ESG. Can you explain that a little further and give a few tangible examples?
Yeah, sure. So, for instance, one of the key principles that everyone knows and that with which every company is fighting actually is the data retention limitation principle. We know how difficult it is to comply with this principle because most of the time in the reality, our IT teams tell us, well, it's difficult to make sure that your written recommendation in terms of how long I need to keep the data is actually implemented. It's really difficult to make sure that when I delete the data in this system, it will not have an impact on other systems and so on. So we know that that's a long fight as lawyers on data protection that we have with the business teams on data retention. But now a new argument comes with us. Not only the problem of compliance with the GDPR is on the table, but also, it brings on the table the fact that the more you keep data, the longer you keep data, the more space you use in the cloud. And using space in the cloud triggers use of energy. So that goes with another logic now, is that we tell them, you need to take some actions because you have some pressure from top management in order to demonstrate that as a company, we are reducing our carbon emission. And here you have a good opportunity. We, as data protection specialists, are able to define some data retention maximum period. So if you apply them, you will tick two boxes: compliance with data protection and compliance with our carbon emission reduction objectives. So that's super interesting in that regard. And the same applies actually in relation to data limitation. Again, it's very similar, so I will not make long development on that one, but again, the more data you collect, the more space you need. Even, sometimes you may have faced this situation that, the business teams, they always want more data in case it's useful in the future. Now we here again have a good argument when talking with them on telling, listen, when you are collecting information just in case you need them in the future, first of all, it's against the data limitation principle, and secondly, you are using energy for nothing or just in case. So again, highlighting the contradiction help us as privacy professionals, internally to actually have some key principles on data protection implemented in a faster way, if I can say. Mm-hmm. So that's something I found interesting to highlight and which works quite well actually.
Thank you. And on the S, Gintari, what's your perspective on the S of ESG, the social elements, and GDPR?
So I think it was already said, but it's worth recalling, that right to data protection is a fundamental right. It is protected by EU Charter. It's also a human right, protected in the European Convention of Human Rights. And recital 4 of the GDPR goes as far as saying that data protection should be designed to serve mankind. So there is this very human-centric approach in the GDPR, the core at this regulation. And in particularly, it is expressed in Article 5 when it comes to data protection principles. So, of course, we often, speak about data minimization and so on. But, of course, we also have transparency and we also have fairness, which is very important and something that is often kind of, gets lost because, of course, everyone focuses on these very, concrete requirements, for example, in Chapter 4. But actually, the principles are at the core and they are also, they can be subject to enforcement action. The infringements of principles can also be subject to fines. And now what we are seeing also the data protection authorities are taking this more proactively, and there are already first decisions that also find infringement of the principles. And for example, when it comes to fairness, it might be hard, to articulate what does it mean in practice. But EDPB has also done guidelines on trying to explain a bit, the content of this. And first of all, it relates, for example, to that controllers should avoid the deception of data subjects. The example of this could be what so-called dark patterns that we see a lot first of all, everyone thinks of social media, but also any other services. When you go online and you are kind of, you are in the situation where you ask for consent, and there are certain colors used, certain words, and so on. So this is one example. This shouldn't be. This should be a proactive approach, and the controller shouldn't invoke these kind of practices that kind of puts data subjects in these situations where they really, in fact, we have no choice, or they are without full information being pushed towards a choice which is detrimental to their rights. And there is also element of non-discrimination, which is very interesting there as well, because in some cases the processing can lead to decisions that affect different groups of data subjects. So this is also something coming from fairness element. So these are just a couple of examples. Then there are more automation and AI being used and profiling, and there are also decisions, dealing, for example, with social scoring and how this is being designed, and whether that takes into account these more general obligations of fairness and non-discrimination. And then there is also focus on vulnerable groups. So this is, of course, relevant for companies, for example, who are providing services that are targeting children or are often used by children, to consider also specific risks that they are exposed to, and how also to communicate to them about the processing of their data. There are certain requirements, how to collect consent, how to collect parental consent in some cases, and also applied measures such as age verification in case there is evidence that the services can be used by children who are, of course, not always aware of all the risks to the same level as adults would be. So this could be example. And then, the automated decision-making and profiling is also something that is becoming more and more a reality. And there are also these elements of being able to, understand what algorithms are being used, and also being able to explain to people how they are designed, so they can also be aware of this and exercise their rights accordingly. So all of this is kind of providing for a basis to go beyond, the right of access requirements and so on, but also to look at the real impact that some processing can have on people.
Thank you very much. And I think if I look a little at our practice at CMS, we do a lot of data breaches, cybersecurity incidents. By far the most common one in Europe today, unfortunately, is cyber ransomware attacks, whereby two things happen. Basically, the company's light goes out, sometimes literally. But second, before your systems, your data are being encrypted, the threat actor steals data and then leaks the data, unless, of course, the victim pays ridiculous amounts in ransom. Now, everybody knows that, but behind the scenes, what very often is happening when an organization falls victim to ransomware attack is, because the light goes out, employees have no work anymore. I mean, that doesn't mean that they're laid off on a permanent basis, but at least for a couple of weeks, sometimes even a couple of months, they've been put on technical unemployment. So there's a very clear link between protecting the data of your own employees, your customers, and data in general on the one hand, and protecting your own workforce and their social status. So there's a clear link there, I think, with the S as well. There's an excellent report by Sustainalytics. It's basically a service that's been offered by Morningstar. Morningstar is an advisor for investors. They actually rate funds and all sorts of financial assets. They actually issued a very interesting report on basically cybersecurity and how important and vital it is for ESG. And I know it's a specific subset of GDPR, but it's as much GDPR as it is anything else. So that's one thing. The other thing, I think, to profiling, I couldn't agree more. People often think about fancy, super sophisticated stuff, but it's happening as we speak. Many automotive companies, for example, provide UBI insurance premiums, insurance packages, whereby basically you're paying only on the basis of your own driving behavior. If you're driving, of course, a connected car. The connected car collects information about you, feeds that into an organization that makes a profile of yours, gives you a score, and out comes a certain premium amount. And if you've been driving a lot at weekends past 10 o'clock in the evening, you're likely to be paying more than if you're a 48 years old lawyer only works during the day as me, and I only drive at business days during business hours, so I'm making less. Well, there's a clear link between collection of data and ethical ways of profiling people, and on the other hand, the social impact, how much are you going to be paying? So I think this is not just a theoretical or economic discussion. And I'll pause here. If there's any questions or any thoughts you wanted to share, or why not, if anything you disagree with, please, feel free and go ahead. Yes, we got a few questions.
Hi,
go ahead.
Yeah.
Sure.
Yeah, my name is Kris. I'm from Leiden University. So we're studying law and digital technologies at World's Masters. So regarding this topic, we have come across some material which says that companies engage in greenwashing and ethics washing, where they show that they're environment friendly and they're like ethical in their behavior, but that is just like something they portray so that they can like act like an environment friendly company. So from like a consultant's perspective or from a regulatory perspective, how do you sort of identify a company which is genuinely contributing towards ESG principles versus a company that is doing it to just like do some sort of ethics washing and like legitimizing their unethical practices? Like, how do you go behind the external image and like dig deep into it?
You want me to comment? So I can jump on that one. Actually, I mean, it's difficult, I believe, to actually make the difference. But as I mentioned earlier, I believe the regulation, and in particular CSRD, will help on limiting greenwashing. And there is also another piece of legislation in the pipe for the coming years to limit greenwashing. But one of the key will be auditability of the KPIs. Again, it's easy now, to say and claim that you are reducing your carbon emission. But if behind, there are some audits that are carried out, that's where you will be able to make the difference. So for instance, when you are a company or an investor who wants to contract with another company and you suspect that company to do greenwashing, maybe in the future, we could leverage on the audit section in the contract in order, as part of your audit, when you will activate the audit clause in the contract with your provider, you could have a section on sustainability and ask for some evidences on, whether you are facing a company which is actually doing greenwashing or not. That's point one. Point two, in relation to the auditability and the tracking, I think that, companies which will be able to demonstrate also a robust governance on how they are keeping track of their carbon emission and so on, will be, also another indicator of a company which takes it seriously or another one which just want to claim that they are green. So again, the solution all in all is about auditability and having a strong governance in place in order to limit the sole public communication on the matter.
Yeah, just to build further on that, I think auditability is one thing. Of course, the average auditor will come across and say, well, what do I need to audit against, right? And this is a little segue to the importance of standards. Because nothing is auditable unless there's a standards framework that the auditors can come in and test you against. So I think GRI, SASB are two of these widely known, globally known standards, which might be a reason for organizations to basically use these to build your own ESG program and framework on. I thought there were a few more questions, a few more hands raised. And if you wouldn't mind picking up the microphone, because I think it's been recorded and it might be difficult for people afterwards looking at the video to understand the questions. The lady there, if you could go first.
Thank you. Thank you for the panel. I would like the panel to address another aspect of the S of sustainability, the social aspect, in regards with the workforce, the sustainability response of the company vis-a-vis their workforce. It sometimes is not as important as the consumers. In particular, would you have any views regarding their obligations to limit their monitoring practices or surveillance practices on their own workforce? My name is Aida Ponce del Castillo, and I work for the European Trade Union Institute as a researcher. I often accompany workers in order to negotiate or bargain data vis-a-vis a company. And in the 3 cases that I have been dealing with very large companies, they don't want to speak about GDPR, and they say monitoring worker is not something that we can bargain. So it's very difficult, and I would like to know, I know what the law says, but still, I would like to know your views, please. Thank you very much.
That's a very interesting perspective. Gintari, would you mind?
Yes, sure. I agree. It's a very important element. And actually, maybe we would have spoken about that at the end. But it's true. This is a very important part. And I think it's no. I mean, from Data Protection Authority's point of view, the position is very clear. You know that. I think there also EDPB has issued positions on that, and the fact that the relationship between employee and employer, especially is often imbalanced. So there are of course extra safeguards that need to be applied, and there is always when we apply GDPR to these situations, we always need to look from the perspective of an employee as being a weaker party. So certain type of practices, they always have to be assessed if this is something that is proportionate to the aim pursued, and is it really necessary, and if there are no means that are could be used instead. And I think it's clear that it of course depends on case by case assessment, but certain monitoring practices, they have to be really substantiated, and they have to be designed in a way that comply with the data protection principles. But in general monitoring, I think many DPAs would raise concerns about that and act in these cases. So, but it is of course very, very important element when we speak about also the ECG and what kind of. But of course, the social part is also about the workforce, and I completely agree that we have to highlight this point.
Well, if I can be a little bit the devil's advocate, I think the one thing that makes this topic challenging is basically it's not either one or the other side of the line. I think some organizations, especially when they deal with a lot of information, whether they be confidential information or security information, for example, if you're operating a nuclear power plant, or if you are basically fragile for cyber attacks, for example, you might need and have a compelling reason to do certain employee monitoring, right? So in a way, I appreciate that an outright statement that there's no bargaining on employee monitoring, that perhaps is a few lines for you bridges too far. But I can imagine if only it were to protect your own workforce or for your own customers, there might be room and certain social element into monitoring certain systems and the use that your staff make of those systems. Again, for example, if you're in automotive and you have petabytes of geolocation information coming through by all the cars that drive around in Europe, your brand in a certain platform on the cloud, you'd rather want to make sure that that environment is highly protected, and that only those employees that are allowed to access those do actually access those data, and only to the extent they need that. So you might need to have not just only a role-based access control framework in place, you might not just need to audit that, but in case there is suspicion of abuse, you need to monitor this. And I appreciate that's perhaps an easy example. I think where it becomes really tricky is the gray zones, right? Again, the nuclear power plant is an easy one as well. I think you'd expect the average energy provider to do at least some monitoring of employees, if only were for security purposes. So I think the gray zone sits somewhere in between the two ends of the spectrum.
And if I may, I think you need to have some arguments with the companies you are working with who don't want to hear about GDPR. Quite surprising in 2023, but anyway. I think one point you could highlight in relation to ESG and data protection is that most of the new talents which are coming on the market, the new candidates, the young candidates, are very conscious, more conscious and more sensitive on the sustainability approach of companies. So if you are, trying to attract or retain talents and you are a company saying, well, data protection, it's okay, it's important, but when it matters, when it relates to monitoring employees, it's more important to monitor employees, that will not work. And I think that could be an argument, saying that if you are able to demonstrate that you are conscious about the importance of data protection for the employees and be mindful about the data protection principles in relation to employee monitoring, that could be a good argument as well to attract the best talent and retain them in your teams.
There's a few more questions there. Perhaps the lady in the right inside.
Hello, thank you for the panel. So my name is Laura Linkomies. I work for Privacy Laws and Business Reports. And I'd like first to ask Gentari about the specific work of the EDPB. Forgive me if this was mentioned at the beginning because I arrived a few minutes late, but are you planning to issue a specific guideline or paper, particularly on the data protection aspects of the European Green Deal? And then I would like to ask Emmanuel about the non-EU countries. You mentioned that you have presence in 50 countries. So have you had any sort of resistance or reluctance in the non-EU countries to start collecting all these KPIs and go with your big plan? Thank you.
Yes, just to your question, for the moment there are no immediate plans to actually issue something specifically on that. But it's always a changing environment, and this might happen. That we change. But for the moment, we are not working on some specific document. But there are elements that might, be addressed in other guidelines.
So on the large scale of our program, so two things. The first being that our group data protection policy, or our BCR, are really binding against all the entities of the group. So from scratch, our approach has been to say, irrespective of the local legislation in the country where we operate, we want to have the same baseline and to apply the same rules in the group. So that had been a long change, and completely apart from the discussion on sustainability, where we have taken, with the support of the top management, the approach of saying, it's not because we are operating half in India and partly in Morocco, etc., but because the legislation there are weaker than the GDPR, that we will not apply the same standards. So that's point one, is that the culture that we have imposed on data protection since a long time is to say there is no difference wherever we operate. We take the higher standard. And the second point, when we link it to the discussion on sustainability, again, there had been a strong push from the top management and strong messages with important objectives in terms of sustainability, which has put some pressure on the local top management, including out of the EU. So that indeed, luckily, we didn't face so much resistance on, having a global approach rather than being very much EU-centric. So even though it's true that initially that's a topic, both data protection and also sustainability, which is very much EU-centric, there is not so much resistance. Interestingly, it's true that, for instance, in the US, the legislation, both on data protection and on sustainability, is so I would say, parcellar, and sectorial, that sometimes it's a bit more difficult to have the business be mindful about those two topics. But still, again, as a matter of trainings, of education, of making the topic not only a compliance topic, but more a business topic, in the end, they realize that they don't have so much choice, so we didn't face so much difficulties so far.
Thank you. I think there was another question at the bottom of the room.
Hello, my name is Tatiana Duarte. I'm a researcher here at the VUB in Brussels, and I am studying compliance with data protection precisely, but I can see in my research some connections, many connections between environmental law and data protection law, either in the policy-making part and also in the practical part, in the sense that people obliged to comply to compliance obligations, they need to develop laws and norms and regulations, internal regulations, to deal with these topics. So I was wondering, how do you see, because I can see that environmental law has been grown or at least its development in the European Union, it's a bit older, I think, than data protection law itself. And I was wondering whether you see a parallel continuity. So in the sense that what can data protection law learn from the developments in environmental law? Or to what extent these objectives actually might be at odds, because data protection in companies is many more about growth. Yesterday we had a talk on that, the lecture by Julie Cohen. So I was wondering, what are your thoughts on the policy for the DPB representative and the practical part? How is it for companies to make that connection between data protection and environment?
I can just say that it's very interesting perspective. So I don't think we really have like a discussion in that sense, in this detail. So I can, only share my first personal reaction. I think it's very interesting. I mean, data protection is kind of, it's also been there for some time. But the issue, it's not the issue. I think it's kind of strength and its weakness sometimes is that it's really based on principles. So that's in a way because, it applies, there's a similarity as well. Like it's kind of horizontal and it's not based on specific technology. So it has to be like, I think it's the right approach that it's kind of principle based and then you specify in some specific cases. I'm not sure it can go to be more detailed. That might go against, the efficiency of regulation and so on. But and we are, Viv, in the EDPB, we kind of, we're talking about that it's already 5 years, but we are learning a lot every day. Like basically every day we're facing questions that are new, and we have to learn also from other fields sometimes of EU law to see how things were done because it's administrative law. So I guess it makes sense to make that link, but I'm not sure necessarily it's evident for everybody, to be honest, today. Again, you can also see like personal data is certain resource, and then that some would like to exploit and so on. So it's a very interesting perspective. Thank you for that.
I mean, from my point of view, it's indeed difficult to make a real correlation or have data protection learning from environmental law. Historically, data protection is learning more from competition law. Also, when we decided and defined at the time, back in 2012, the process in the GDPR for sanctions, enforcement, and so on, that was very much inspired from competition law. But I have never seen any real reflection on parallelism or inspiration from data protection on the environmental regulation. So I would not be able to further elaborate on that point, apart from what we said today, meaning that on the contrary, data protection can contribute to the efforts under compliance on the environmental regulations at large, that's for sure. But having data protection been inspired on some environmental law, I don't see that in practice.
Thank you very much. There was another question in front. Thank you for your patience, by the way.
Hi. Firstly, I want to say thank you again for this panel. Secondly, my name is Timur, and I am a DPO, one of the company. And our problem is that we struggle with obtaining the parental consent. For children. So my question to Isabel. Are you planning to share any additional maybe guidelines about the parental consent? At the first question, and the second to Emmanuel. Yes. Mm-hmm. Yeah. Can you provide any maybe tips or hints how we can, as a DPO, actually sell this idea about privacy and data protection and all of this stuff to our shareholders? So basically.
So I can take the first question. In fact, EDPB has in its plans guidelines on children's rights. So that should be possibly also covering the issue of parental consent, because that's indeed quite complex matter, and there are a lot of questions around it. So there is something in a pipeline on that, but I cannot provide any timeline, and it's quite complex. It might take some time, but there is something in the pipeline on that.
Yeah, thanks.
I think also in the US you have some more guidance with the COPA legislation, which may help on children's data.
Exactly.
That helps because indeed at the moment in Europe it's.
Yes, so that's we wondering how we can do our business in Europe, because in States we have a COPA, and we apply this email plus consent, but we don't do it in Europe because our shareholders already start screaming that now it's additional iteration, we lose a lot of money and we don't care about this. So that's so any tips?
Yeah, so any tips? So maybe the first thing is to ensure that you have a strong data protection program internally, because you will not be able to go to your top management saying, I want data protection to support sustainability if your positioning and your organization is quite weak. So very first thing is to be robust and have some good talking points as to how to present and promote your governance on data protection. The second one would be simply to take and print out the SASB standards and extract from there the privacy sections in which you have a list of indicators, as I was referring to, relating to privacy. And you come with these SASB standards to your management and you tell them, listen, these are the elements which are currently looked by the investors in relation to sustainability at large, and more precisely here on data protection. So that would be already, starting the conversation and be part of the story, you could say. And finally, I would also be promoting and make some kind of, that's what we've done actually, some kind of one-pager or infographic, where you actually illustrate what we said before, with the key data protection principles and how they can have an impact on environment, on the gas emission and so on. That makes it a bit sexy and real, So but these are the three things I would suggest to tackle in order to make it more approachable by your management.
Yeah, thanks.
Well, one of the advantages, or call it the disadvantages, I think, if you look at today, the average boardroom, sustainability is clearly on the table. That doesn't mean that the average company knows how to do it, but at least the traction is there, right? And I think it's fair to say, perhaps you're the slightly more advanced in the whole discussion, but I think it's fair to say many multinational companies will look at sustainability first and foremost from the E and the S perspective. And data privacy isn't naturally seen as part of this, right? So I think there's some challenge there, but at least the traction is there. And I think we have this conversation with many clients who have been reporting on sustainability and who start to discover, well, hang on, this data protection element naturally fits in it. And even better, SSB and GDR, GRI, they all have this as part of their standards. So it's not something super exotic or super innovative. We're not inventing the wheel as we speak.
And also because of the size of our company, we are very much under the investor scrutiny. And our investment communication team has noticed that over the last 2 years, the investors are organizing specific calls dedicated to data protection because they want to better understand what is our data protection approach and so on, and they value it in their overall assessment of the company from a financial perspective. So that's super interesting because in the end the pressure comes from the market, and it's always the best way on how to leverage on topics,
And to convince your board members, right?
Yeah.
Thank you very much, all. I'm afraid we're running over time.
Thank you.
Unless there's any further final questions, we can take them offline after the session. Thank you for coming at this early moment of the day, and enjoy the rest of the conference.
Thank you.